This tutorial is produced by the Mecklenburg County Clerk of Superior Court, Estates Division. While our office cannot provide legal advice, we are happy to help you navigate the estates administration process. This video will provide a step-by-step guide to completing the Renunciation of Right to Qualify for Letters form, AOC-E-200. First, let's define some of the terms used in this tutorial with which you may not be familiar. Decedent, a person who has died. Testate, the decedent died leaving a last will and testament. Intestate, the decedent died without leaving a last will and testament, or the decedent has left a will that cannot be probated. Executor, a person the decedent named in a will to be in charge of the administration of the estate. Administrator CTA, a person who has been appointed by the court to administer a testate estate. This occurs when the decedent has left a will but did not name an executor, or when the person named in the will is unable to perform the role of executor. Administrator, the person in charge of the administration of the estate when no will has been probated. Personal representative, a person who has been appointed to administer an estate. This term may refer to an executor, an administrator, or an administrator CTA. What is the purpose of this form? When a person who does not have the highest priority of appointment is applying to the court for the right to serve as personal representative of a decedent's estate, anyone with a higher priority than the applicant may renounce the right to do so. When this is done in writing, it is called an express renunciation. When the person making the express renunciation has authority to nominate another qualified person to act as the personal representative, the person who was nominated will then have the same priority as the person who has renounced the right to qualify. In an intestate estate, the person with the highest priority of appointment will have the authority to nominate a qualified person of his or her choosing. In a testate estate, the will must clearly grant the named executor the right to nominate his or her replacement. Who has priority of appointment as personal representative? The court will grant letters of appointment to a person who applies and is qualified to serve in the following order of priority. The primary executor named in the will. A substitute or successor executor named in the will. If the will grants a person the authority to nominate a successor, then this nominee. The decedent's surviving spouse. Any heir of the decedent. Any next of kin, with those persons of closest kinship taking priority. Any creditor who is owed money by the decedent before the decedent's death. Any person of good character residing in Mecklenburg County who applies, or any other person of good character who is not disqualified. Enter the name of the county. Enter the decedent's name. Check box 1 if an executor who is named in the will wishes to renounce his or her right to qualify as executor. Check box 2 if a qualified person wishes to renounce his or her right to qualify as administrator. If the person who is renouncing has the authority to nominate a successor, he or she may print the name of the nominee here. The person who is renouncing must print the date and his or her name on the form. The signature portion should be left blank until the signature can be witnessed by a person who is an adult who is not a family member. Up to 4 individuals may use the same form. When the form has been completed, it may be returned to the personal representative so that it may be submitted with the rest of the personal representative's paperwork. If the personal representative's other paperwork has already been submitted to the clerk's office, then the form may either be brought to the Mecklenburg County Courthouse and dropped off, or mailed to the following address: Clerk of Superior Court, Estates Division, P.O. Box 37971, Charlotte, North Carolina 28237. I hope this information has been helpful. We look forward to assisting you.